Today we are going to be covering Chapter 6, the purpose of criminal punishment. I would like to note at the beginning of this PowerPoint that as we get through towards slide 17, you are going to see the term just deserts, although it is spelled just deserts. Please note that in the criminal justice system, we do consider this just deserts, but it is spelled like just desert. What is punishment? Punishment describes anything we think of as painful. Flew argues that punishment will consist of 5 elements. It must involve an unpleasantness to the victim. It must be for an offense, actual or supposed. It must be for an offender, actual or supposed. It must be the work of personal agencies. In other words, it must not be the natural consequence of an action, and it must be imposed by an authority or institution against whose rule and the offense has been committed. Bean and Peters add the censure element, which states that unpleasantness should be an essential part for the punishment. Freenberg adds that hard treatment element, which states that the punishment should also reflect attitudes of resentment and indignation and judgments of disapproval and reprobation on the part of the punishing authority himself or of those in whose name the punishment is being inflicted. Another definition of punishment that is proposed by Garland is the legal process whereby a violator of a criminal law is condemned and sanctioned in accordance with specific legal categories and procedures. The question of why offenders should be punished produces many possible conflicting responses. Some answers are based on reasons having to do with preventing crime. Others are concerned with punishments being deserved by an offender. Over time, there has been a shift in the penal theory and therefore its purpose for punishment. For moral philosophers, the ought of punishment leads to a set of questions that include: what should be the goal of the punishment? What should be the values contained in and promoted by the criminal law? And what is the purpose of the punishment? The sociological perspective is concerned with what punishment is actually intended for and the nature of the penal system. Criminologists and policymakers offer a third perspective on punishment discussed in Chapter 7. There are 2 main types of theories for punishment: the utilitarian theory and the retributive theory. These theories have a set of goals for punishment as the prevention of future crime or deterrence, as usually reflected in the utilitarianism because they are derived from utilitarianism philosophy. Past-oriented theories, or theories that focus on past actions of the offender, are referred to as the retributivism because they seek retribution for offenders for their crimes. There are also theories of rehabilitation and incapacitation. There is also the idea of restorative justice. People are deterred from actions when they refrain from carrying them out because they are experiencing an aversion to the possible consequences. Walker says that it is hard to determine whether this kind of punishment or penalty or its severity has any effect on whether it is successful or not. Some question whether deterrence is normally or morally accepted. Punishment can be justified only if the harm that it prevents is greater than the harm inflicted on the offender through the punishment itself. Unless punishment deters further crime, it simply adds to the totality of human suffering. The utilitarianism theory is a consequentialist theory that considers only the good and the bad consequences that are produced by an act as being morally significant. Deterrence is a forward-looking punishment theory because it looks to the future of criminality. Utilitarianism theories of punishment suffer from the punishing the innocent objective. This states that if punishing a person is morally justified because it results in more utility than an alternative, then in some circumstances, punishing the innocent is also morally permissible. There can also be cases where the most utility is produced by not punishing the guilty person. Individual deterrence involves deterring someone who has already offended from reoffending. General deterrence involves dissuading potential offenders from offending at all by the way of the punishment administered for a particular offense. The empirical evidence suggests that generally punishment has no individual deterrent effect. Walker argues that evidence for research studies have established that capital punishment has no greater effect than life in prison. Nagin identifies 3 sets of studies. A time series study explores the effect of a specific policy initiative. The ecological studies looks for a negative association between crime rates and punishment levels that can be interpreted as having a deterrent effect. In perceptual studies, the data comes from surveys. And Danes explains the 2 positions are usually debated. Bentham's position is that a man is a rational being who chooses between the course of action, having first calculated the risk of the pain and pleasure. The alternative position argues that people remain law-abiding not because they fear the criminal law, but as a result of the moral inhibitions and norms of conduct. Anthes points out the dangers of generalization, suggesting that it is necessary to distinguish between the various offenses. He continues to note that the threat of punishment, although direct to all persons, affects individuals in different ways. Tollett concludes that the multiple regression studies show empirically that the increase in the frequency or severity of punishment does reduce the likelihood of a given crime being committed. Blumstein, Cohen, and Nagin contend that it does not necessarily establish the general deterrent effect of sanctions. This is because, in their view, the negative association can be explained by lower sanctions being the effect and not the cause of higher crime rates. Overall, there seems to be little agreement among researchers that punishment has a general deterrence effect. If various forms of punishment would achieve the same results, a utilitarianism would opt for the more lenient punishment that minimizes the potential suffering. This approach can result in the infliction of excessive punishment. If a newly enacted law were to impose a punishment of 10 years imprisonment on a petty theft, and no less a penalty would be the deterrent effect, utilitarianism would have to accept that an excessive sentence for one petty theft is unlikely enough to be arrested and convicted. Retribution is a theory that punishment is justified because it is deserved. Retribution does not concern itself with public good, the safety or security of society, and the moral improvement of the criminal. Retributionists claim a moral link between punishment and guilt and see punishment as a question of responsibility or accountability. A retributionist will see legal rules as representing and reflecting the moral order. Society's acceptance of legal rules means that they will accept the rules whatever they may be. They will accept the rule makers are justified in making their rules, and they will also claim that those who make the rules provide the more moral climate under which others may live. This position makes no allowance for social change or social conditions, and these individuals look backwards because in punishing people for a wrongful act they have already performed. Researchers have suggested that the historical term of lex talionis sets a limit on the nature of that retribution and therefore prevents the imposition of excessive penalties. This basic principle is that punishment should inflict the same on offenders as offenders have inflicted on their victims. There are many crimes to which this cannot be applied. It also makes no allowance for a mental state of an offender or for any mitigating or aggravating circumstances that are associated with the crime. Kramer argues that this is qualitative rather than quantitative in nature and therefore should not call for a punishment of matching severity to a crime. A further objection is found in the view in a civilized society. Certain forms of punishment are considered too cruel to be defended as valid or appropriate. There is a notion that retribution is a payment for what is owed, that is, an offender who is being punished is paying their debt to society. Walker notes that this seems to confuse the victim with society. Censure is holding individuals accountable for their conduct and involves conveying the message to perpetrators that they have willingly injured someone. They will face the disapproval of a society for that reason. Censure can have a deterrent effect. Some theorists of desert argue that hard treatment is needed to properly express societal disapproval. The denunciation theory holds that punishment is morally justified because it gives satisfaction. The notion of the expressive or communicative character of punishment recognizes punishment as comparing not merely harsh treatment, but also elements of condemnation, denunciation, and censure. Philosophers see a main benefit of punishment as the effect of restoring the offender to the community. The dehumanization theory describes the view that offenders are less than human or irredeemably evil, which refers to the denial of the attributions that are uniquely human. According to Duff, this notion asserts that punishment communicates to the criminal that censure they deserve for their crime. The element of communication requires that the person to whom the communication is directed must receive and respond publicly to the communication. The communication should appeal to the person's rational understanding. In the context of criminal law, punishment must be communicated in the formal conviction of guilt through a system of harsh punishments such as imprisonment, fines, or community service. Offenders should also accept that punishment is deserved and penance, not merely an apology, as expected of the offender. Duff believes that incarceration should be significantly reduced, but sees it as having a value as a shock to repentance. Other researchers contend that the prison regime should at least be compatible with both a moral reform and reconciliation. One problem with the communicative theory is that we have unrepenting offenders. The unfair advantage theory holds that an offender should be viewed as a person who has taken an unfair advantage of others in society by committing a crime that has imposing punishment which restores fairness. Morris argues that the effect of criminal law is to confer benefits on society because others are not permitted to interfere with areas of an individual's life. To gain the benefit of non-interference, individuals must exercise self-resistance and not engage in acts that infringe on the protected areas of the lives of others. Punishment is justified because it removes this unfair advantage and restores the balance of benefits and burdens distributed by the criminal activity. Morris has been criticized for failing to acknowledge that we feel offenders ought to be punished because their wrongdoing is inherently wrong. It also argues that there is an unfair advantage theory that distorts the nature of crime itself. Critics of the retributionist theory of punishment argue that retribution is basically nothing more than vengeance. Critics argue that there is a clear distinction between the two because retribution is done for a wrong, while revenge may be done for an injury or a harm or a slight and need not to be wrong. A further distinction between the two is that retribution in the form of punishment is inflicted only on an offender because revenge may be carried out on an innocent person, perhaps a relative of a perpetrator. Up until about 1970, criminologists generally thought of retribution as vengeance. During the 1970s, they reconsidered the idea of retribution in an advanced new formulation. By the 1980s, the new retributionist theory of just deserts had become influential. This theory holds that punishment for violating the law is morally permissible because offenders deserve to be punished. This theory gained support as a reaction against the perceived unfairness of systems that favored treatment, especially those that used an indeterminate sentencing model. Kant argued that the aim of the penalties must be to inflict desert, and that it was a categorically imperative. He meant that inflicting what was deserved rendered all other considerations irrelevant. He argued in favor of a stricter equality between the wrongdoing and the punishment. One problem with strict equality is that sanctions for very harsh punishments might be different in character between the crime and what would constitute a punishment for that crime. Proponents emphasized the notion that punishment should be proportional. There should be a scale for punishments. The most severe are reserved for the most serious offenses. Penalties should be assessed according to the seriousness of the offense, and this should be used on a tariff sentencing. Advocates focused on the two dimensions only, the harm involved in the offense and the offender's culpability. These theorists now emphasize that responding to criminal acts with a process of blaming encourages the individual to recognize the wrongfulness of their actions, to feel remorse, to make efforts to refrain from such conduct in the future. Issues include the situation of a person who breaks the law but does not deserve to be punished, as well as there are people who do not break the law but nevertheless do deserve to suffer punishment. Issue arises as to how offenses are to be ranked in terms of the seriousness. In some jurisdictions, the judge's view determines the issue. Other approaches include the use of sentencing commissions or legislation for a sentencing schedule. Von Erst insists that just desert itself does not call for a harsher punishment, and that sentencing schemes rely specifically on this theory and tend not to be severe. Theorists contend that this model ought to prescribe proportionality sentences for juveniles, but that the sentence should be scaled down according to a juvenile's age. The fundamental difficulty with this theory is that it lacks any principle that determines a properly commensurated sentence. Tonry notes that the principle of proportionality has not been adhered to in countries like the United States and the United Kingdom. He continues that the theory does, however, support two principles. No one should be punished more severely than they deserve, and persons who commit serious crimes should be punished more severely than those who commit a less serious crime. Crime seriousness is generally taken to be a composition of the actual harm done or threatening and the blameworthiness or culpability of a person who committed the act. One problem with this formulation is that there is no conventional measure of what is to be considered serious. A second problem is the harm caused to the victim of the crime because victimization is specific. The third problem with the seriousness is that while an offender might intend a specific harm, what happens in reality is often a matter of chance or luck. Whether a particular prison sentence is severe is also problematic because a sentence will be experienced differently by persons according to their age, mental state, or previous criminal record. Many argue that retribution based off of this theory fails to account for the problems and is just in an unjust world. Zimring suggests that this sentencing fails to account for the fact that there are multiple discretions involved in sentencing power. Deggan and Roberts note that the retribution and this theory reject parole. The contrast between these two theories lies in the fact that for utilitarianism, the aim of punishment is to control future action, and for a retributionist, this is to see the aim in terms of just desert. If the sentencer is a utilitarianism, he or she will be concerned only about whether a remorseful offender will be less likely to reoffend. For a retributionist, the question is whether remorse should be mitigated culpability. According to Walker, forgiveness has no degrees, but may take the form of interested or disinterested forgiveness. Mercy is distinguished from forgiveness because granting mercy is an act, but forgiveness is an attitude of the mind. Many philosophers opt for a hybrid solution in the problem of punishment. Mixed retribution argues for punishment as an institution to be justified on utilitarian grounds, whereas its actual implementation is to be justified on a retributive ground. The just punishment is built on an ethically based framework in which punishment must meet several criteria. Rehabilitation is a complex notion involving an examination of the offense and the criminal and a concern for the criminal's social background and punishment. Utilitarian theory argues that a punishment should be reformative and rehabilitative in its effect on the offender. The deontological theory argues that we should rehabilitate criminals because it is just the right thing to do and because each person poses moral worth. Proponents for rehabilitation and punishment argue that punishment should be tailored to fit the offender and his or her needs rather than fitting the offense. Bean outlines the strengths of the rehabilitation position as being its emphasis on the personal lives of the offender, its treatment of people as individuals, its capacity to produce new thinking in an otherwise rigid penal system. Rehabilitation theory tends to see crime as predetermined by social circumstances rather than as a matter of choice by the offender. Modern rehabilitationists argue that this is fixed rather than a determinate sentence and should be in the context for rehabilitation. By the 1980s, the retributionist theory of just deserts has become the most influential theory of punishment. The effectiveness of rehabilitation is assessed almost entirely by reference to the officially recorded offenses. Lipsey and others identified 4 themes that have produced effectiveness. Programs that target criminal conduct directly or specific causes of criminality, as opposed to a fear-based or punitive approach. Programs that incorporate structure, such as training, as a primary component. Programs that use multiple treatment strategies, and that treatment needs to be extensive enough to be effective. Day argues that many rehabilitative programs fail for reasons of incompetency and a lack of staff commitment to their principles. Rehabilitationists contend that their rationale for punishment is the only one that combines crime reduction with respect for an offender's rights. State-obligated rehabilitation contends that if a state assumes the right to punish, it should ensure that no more harm is inflicted and that it was intended when the sentence was pronounced. Rotman, for one, argues that a failure to provide rehabilitation amounts to cruel and unusual punishment. Offenders, on their part, have a corresponding obligation to take part in the rehabilitative programs that are offered by the state. Sifner argues that, wherever possible, punishments should preserve opportunities for the rational exercise of character and the development of virtue. The morality of requiring offenders to participate in rehabilitation programs in return for some incentive, such as an early release on parole, has been questioned. Offenders are placed in custody, usually for long periods, to protect the public from the chance of future offending. In utilitarian theory, incapacitation is seen as a good consequence of punishment because when serving their sentences, offenders are removed from society and therefore are unable to commit further offenses. There are 2 basic objections to following a policy of incapacitation based on selecting offenders for this kind of punishment. The first is that predicting criminal dangerousness is problematic and will inevitably mean that a number of persons will suffer incapacitation who would have likely not committed a further crime if they were left free. Second, there is a moral objection that it is wrong in principle to punish offenders based on a prediction of their future conduct. Some of the problems inherent in incapacitation sentencing include that it would work only if we lock up those who have been committing further offenses if they were to be left free. Those we lock up are not immediately replaced by new recruits. The crimes committed after release are not so frequent or serious as to negate the effects of the crimes prevented through incapacitative sentencing. The notion of incapacitation is reflected in such punishment policies as 3-strike legislation, a mandatory minimum sentence, and truth in sentencing. Restorative justice proponents emphasize the need to support both victims and offenders. They see social relationships as a rehabilitative vehicle aimed at providing social support and control for offenders. Since the 1970s, restitution and community service have been employed as sentencing tools in criminal and juvenile courts. During the 1980s, an expansion occurred in a victim-offender mediation program that resulted partly for the interest in restitution and community service programs. It is useful to note the 3 core principles that are suggested by Ness and Strong. Justice requires the healing of victims, offenders, and communities that are injured by a crime. Victims, offenders, and communities should be permitted to actively involve themselves in the justice process in a timely and substantial manner. Roles and responsibilities of the government should be rethought, and it is in the promotion of justice. The government should be responsible for preserving a just order, and the community should be responsible for establishing peace. Mediation programs that focus on achieving a resolution only because of the offender and the victim and leave out the community are normally not considered to be truly restorative processes. Critics of the restorative justice point out that it is too ready assumptions that it will be possible to secure an agreement between an offender, a victim, and a community. Von Hirsch contends that there is no clear principles that have been formulated for restoring the harm done by an offender to a community standards. Public acceptance of restorative justice processes may well depend on a perception that it contains a retributive element. In a restorative detention, an offender undergoes therapy, counseling, and training during the time that they are in custody in a restorative prison. Research has concluded that punishment depends on the physiological argument and more on the currents and movements in social thinking and in climate of tolerance and intolerance. Garland has argued that punishment is the product of social structure and cultural values. Sociologists have expanded this notion of punishment to penalty, the complex of the issues, institutions, and relationships that are involved in the punishment of offenders. According to Durkheim, society has an objective reality apart from the individuals who compose it. He argues that people who behave according to society rules that, together with customs and traditions, form a culture for a particular society. He applies a functional approach to punishment by looking at the functions that punishment fulfills in maintaining a social order. He identifies beliefs and sentiments held by members of a society, which he calls the conscious collectiveness, and argues that crimes are those acts that violate the conscious collective and produce a punitive reaction. He developed two laws of penal evolution. The first is that punishment is more intense the less developed a society is, and a more of a central power within that society in an absolute nature. The second is the notion of punishment having higher intensity, arguing that imprisonment would become the main punishment, replacing death and torture. Garland suggests that Durkheim's analysis of punishment is focused too strongly on the punishment expressive function that causes all explanations to be discarded. Weber's ideas on punishment are applied rather than made explicit. He identifies three types of authority: traditional, charismatic, and legal. He promoted legal authority, the process of making rules by those given the right to rule, as being the most appropriate form of rules for a modern society. He argues that systems of laws might be rational or irrational. In a rational system of criminal law, crimes would be defined and the rules are put forward for adjudicating those crimes. He favored a formal rationale, which he termed a bureaucratic rationality, and saw this as an essential feature of a modern state. Marx's perceptions on punishment evolve out of Marx's concerns for the place of capitalism and the revolutions between production and society. Institutions such as the law are shaped to parallel the relations of production and the maintenance of the capitalist system. Marxist penologists have argued that punishment regulates the supply of labor. The principle of less eligibility argues that the conditions offenders will experience in prison must be worse than anything they are likely to endure outside of prison. This is the restraint of the reserve army of labor for crimes, that is, to serve as a deterrent to lower social classes. Analysis of less eligibility have led to a series of studies that have tested this basic framework. These studies found some correlation between punishment and the labor market in the United States over time. All punishments cannot be understood simply as a response to crime. Foucault presented the notion of penalty and highlights discipline as a key element in the modern form of punishment. His central focus is the exercise of power in modern society and its linkage with knowledge to exercise power of and over the body. He shows how the infliction of pain on the body gave way to an exercise of power throughout the new practices of discipline, the individual through institutions such as the factory and the modern prison. He emphasizes the role of punishment in producing the right-thinking citizen. He adopts a much broader analytic framework than Weber and Durkheim that links punishment and penalty and connects them directly to changes in society and to the exercise of power over an individual.